Welcome to the Rational Egoist. I'm your host, Michael Liebowitz. The Supreme Court has made a lot of momentous decisions recently, and I would like to understand them, and I assume you'd like to understand them as well. So I figured there'd be nobody better to explain them to us than today's guest. He's the Lawrence A. Tisch Professor of Law at New York University. He's the Peter A. Kirsten Senior Fellow at the Hoover Institution, and he's the James Parker Hall Distinguished Service Professor Emeritus and Senior Lecturer at the University of Chicago. Professor Richard A. Epstein, welcome back to the show.
Well, it's nice to be here. I noticed you mentioned that I basically do work in 3 failed states, New York, Illinois, and California. I have to say neither of them are governed in accordance with the classical liberal principles that I generally espouse.
Oh, there aren't many that do.
Unfortunately, I've also been pretty apparent to me that that's the case.
Okay. So first, let me ask you, what are your thoughts about the current composition of the Supreme Court? Are they, as you just mentioned, your classical liberal principles, are they operating, do you believe, in accordance with those principles that you cherish so much?
I think what happens is there was in the Reagan administration a rather concerted effort for many people to think about property rights as the basically the platform on which every other form of rights would develop. I think with the current court, there's a very different emphasis, and it's shared pretty much by all 9 members of the court, which is they think that the intricacies of the administrative state, the doctrines of standing, separation of power, delegations of duty, administrative deference, and so forth, independent of any particular substantive campaign, are where everything lies. And so if you start looking at most of these decisions, they are administrative law decisions which relate to issues that have immense implications with respect to property. If you ask me which of them would think of themselves first as a property rights lawyer and then as an adjectival administrative lawyer, I would say the answer to that question would be 0. The closest person who comes to that, probably Justice Gorsuch, and that's because of his own special academic training, where what he did is he did a lot of studies with John Finnis, having to deal with the sort of the protection of property rights, in part from a classical liberal perspective, but in part from a Christian perspective or a sort of a more Aristotelian perspective, but you want to make it less religious. None of them, I think, would start to say, well, you know, I begin with, nor shall private property be taken for public use without just compensation, and then work outward. What they do is they start to work with all of these questions. Now, there is, of course, a profound difference amongst them, which comes up in most of the cases, but not all of the cases. So if you think there are cases that are clear enough that they don't require any difference, you'll get them all coming out the same way. But if there is a difference, there are 2 very different propositions that do operate, which do influence, of course, the choice between progressivism and classical liberalism. And that is how much deference you start giving to administrative agencies. And I mean this in a very broad sense. That includes the president when he acts by executive orders, and it includes the Congress when it delegates authority to administrative agencies, and it covers the agencies when it starts to use their authority. And essentially, the classical liberal says every grant of delegated power to anybody from the people should be greeted with a presumption of suspicion that it can be abused, and so should be strictly construed. If you're a progressive in the tradition of Woodrow Wilson and his modern peers, you take the opposite assumption. Government is here to do good. It turns out that we elect benign people. And then what we turn out to do is to trust the experts to implement those decisions that are made after rational debate by the public at large. And you'll notice there's very little room for constitutional intervention by the court under a model which distributes the powers in those 2 ways. And there is little question that the minority 3, for all of their differences amongst themselves, essentially adhere to that kind of a model, particularly when there's a Democrat in charge of the government and the presidency. And it's also clear that the other 6, in varying degrees, adhere to the opposite model, and so they're willing to do it. So to give you an illustration of what's going on at this thing, take the Harvard admissions case, or the North Carolina cases, which involve a cross between statutory and constitutional law type principle. If you are Justice Gorsuch and you took a look at this record, you say, oh my God, these guys are playing fast and loose with everything. It turns out the standards are much more different than you think. There's a lot of lying about how it is that It turns out that you managed to demote Asians. There's a huge change in the racial composition of the college. And I just don't think it's copacetic. And I think when they start talking about benefits, they don't talk about it in a way that I would respect. Do the affirmative action candidates do as well as the other candidates? Joe Biden said that they're qualified, but that doesn't mean anything. Are they best qualified candidates is the operative question. And they're far from that in most cases. Now, most of this doesn't sort of come out in the opinion. But when you have looked at that record, it's unmistakable that a lot of these irregularities seem to come front and center, which means that when you look at the constitutional text, you're going to be a little bit more rigid and a little bit more suspicious. And so all of a sudden, equal protection of law 1 applies to those kinds of decisions that are made by government agencies that give benefits. The civil rights law, which is operative under Title IX in the Harvard case, says no law or no exceptions, and you're going to read them very literally, and you're not going to leave any kind of wiggle room. If you're, on the other hand, on the liberal side of this agenda, you have a soft spot with respect to people who come from racial minorities, for women, for any group that you think to be disadvantaged, and you think that a place like Harvard is heroic in the extent that it tries to battle all these hostile oversight commissions in order to secure greater representation of these groups inside the situation. So the skepticism in one case gives you a narrow reading of the Equal Protection Clause, and in the other case, it essentially opens it up to an exception which is big as the clause itself. We can do diversity programs. Nobody wants to run a white supremacist program excessively. So the degree of freedom they have is the only degree of freedom they need, and essentially are now in a complete political environment. So I think, in effect, that's the thing that starts to deal with them. And I say to all sorts of people when they ask me, you're a conservative, how do you get the Supreme Court to come along with it? And I said, strict textualism will not do this, because what will happen is you read these texts and they don't talk about any fluctuation. They say, nor shall private property be taken. They don't say, nor if there's any conceivable justification that you could make for something, then you could take the private property. They just don't do that. And so one group essentially softens the language and the other does not. Predictably, liberals want a greater scope of power, so they're going to be the ones that are going to play fast and loose with languages. A Republican does not need the Chevron doctrine of deference in order to essentially stick to the letter of the law. So they won't expand navigable rivers, so it means everything under the sun. Whereas a Democrat who wants to expand it so it covers land that is near the waters, but may admit something into the waters, they have to have that deference so that land becomes water in the peculiar context of these cases. So these lines are pretty powerfully drawn. And in the biggest cases, they're the ones that did it. I mean, Linda Greenhouse, who I think is all the analyses wrong on the fact, did point to something, which is pretty clear, that the 6-3 lines are very powerful. And there is, quote, a conservative agenda out there, which seems to have prevailed, as opposed to the liberal ones. And I think most people would want to say that I'm something of a maverick. As a classical liberal, I'm not a judicial conservative. I'm not a particular right-winger. I think there are huge grounds, for example, to see why Harvard engages in very difficult negotiation. But I always thought that Justice Roberts was wrong on the Seattle case. That's a case where you have evenly balanced groups trying to figure out a political accommodation. He's an outsider, knows nothing about what's going on there. And to negate that and to try to impose a colorblind solution seems silly. At Harvard, I would love to have an intermediate position. In fact, I've taken that position publicly, that if you ran the programs as I would run them, constantly aware of the trade-offs, constantly aware of the history, you'd kind of do a little of this stuff, it would be inconsistent. It would be consistent with the Equal Protection Clause, which always has to give greater deference to government when it administers a program than when it tries to impose a criminal law. But as far as I can see, there's nothing whatsoever to give me any confidence that Harvard's trying to play that balancing game. Everything they said says, we're just going over the top on these kinds of things. And so I can understand why you would want to be hostile to what these universities do in a way which I would not want to be hostile in a way these communities do. That distinction is completely lost, I think it's said, in these kinds of discussions, but I tend to think that it's kind of right. So, you know, as they say, if you're being hammered from the left and hammered from the right at the same time, you're probably in a pretty good place.
Well, and I'm in a good place because I get hammered by them all. I get accused of bias by both sides.
Good.
So this is what kind of, I'm not going to say confuses me, but Harvard is a private university. And
Yes.
as a libertarian or classical liberal, I am all for private property rights, and they can run their organization however they want. So if they're a strictly private institution, I don't see any problem if they want to have an affirmative action program or anything else. But then I'm told that the problem is that they take government money, and therefore they have to comply with the government. And okay, I'll go with that. But it seems to me the bigger problem is that the government is involved in the education business at all.
Well, I think you're on to something. Let me state what my position turns out to be. If you had a world in which there were no government subsidies and no government penalty, and you had a lot of private institutions that were competition with one another, let them decide to go. Now, Harvard doesn't believe that. Harvard believes, with every other fashionable liberal institution in the United States, that there's a religious group that wants to organize a university and require daily prayer. You can't possibly allow that, right? Because remember their attitude with respect to the whole question about the cake maker and the photographer and the gay couple, right? They don't have any tolerance. So it's not as though you're finding a university out there which is a libertarian university. They're libertarians for us and only for our position and not for the other guy. What that does is it completely skews the map, because all the quote good guys get their way, all the bad guys don't. And so the reason why I think you like the libertarian view is that it leads to a wide range of institutions that take different positions in different ways. But if you have this two-sided situation where you hammer everybody with the anti-discrimination law whom you don't like and bless everybody whom you do like by ignoring it, that is not the world that you want it to be in. And so if you're messing up one side of the equation, you mess up both sides of the equation, because you go to the Harvard University faculty and say, look, we have a very important question here. We think that the way in which we can suspend affirmative action at Harvard is to repeal the Civil Rights Act as so far as it applies under Title IX to universities, to Title VII to employees. Are you going to join us, guys? And we'll basically support your ability to do whatever you want. And I'll bet you they won't join it. See, so that's what the kind of problem is a constant weight on one side of the equation and on the other. This came out, I just wrote this, but it hasn't been published yet. If you recall the Masterpiece case and the Colorado statute makes it a huge no-no, criminal activity in violation of things to refuse to deal with anybody's sexual orientation, sexual identity, gender identity, you name it, right? There's one thing that's not on that list: religion. So what happens is in 2018 in the Masterpiece case, there's a fellow named Jack, and the case is whether or not a gay baker can decide to refuse to make something which has a message which is essentially antithetical to same-sex marriage, right, and so forth. And the guy says, I refuse to make that. There's no statute, right? And so what happens, they go to the commission, he says, well, if he finds that stuff offensive, he doesn't have to do it. So you now have a situation where I can turn you down and you can't touch me, because what happens is the non-discrimination principle doesn't rule out all the relevant characteristics, it only touches some. And so is this the way in which we want to do it? Now, I have a pretty clear view. I don't think any of the people who demand of Ms. Smith or anybody else that they make wedding cakes are doing it in good faith. In the sense they will get their cake from somewhere else, they'll file this in and send it off to the Colorado Commission and go on their way and let it prosecute them. And so, and what should they do? Well, if they want to get a cake, there are 250 bakers within a stone's throw of where they are. Go to one of them. Don't haunt this guy. So what happens is Justice Gorsuch rightly says it's a form of expression. He treats it as an exception to the non-discrimination law, which he doesn't wish to challenge under his point. And this woman gets pelted with abuse and threats, crashes to a website. Sort of everybody here is worried about dignity and equality. She wins a particular constitutional law case and she's treated like a pariah. It's gang tackling. And so the whole social context is such that there's nobody on the progressive side who seems to be prepared to stop them. So I'm waiting to see something from some official in Colorado saying, look, the Supreme Court has spoken. It has said that this is a form of expression that is protected. We now require that everybody in the state refrain from engaging in certain kinds of activities which blow up websites and threaten her with physical mayhem. These things are tortious against good guys. They're tortious against bad guys. So what's happened is the whole debate is poisoned by the fact that there's this fundamental asymmetry which comes through all of these cases. And when I say I'm alone, is I think if anybody wanted to go after a gay cake maker with that kind of stuff, you should throw the full book at them and so on. It is also the case, by the way, if you look at the Colorado law or any law in any state, and you have a rule which says you can't have signage which indicates you're going to discriminate on sexual orientation, right? You look at every gay site in America, and what do they call themselves? Gay sites. I mean, if you're not gay, they'll take your business and so forth, but the signage is supposed to say you're equally welcome. Nobody cares about what that statute is. So nobody ever enforces against these kinds of organizations, right? They do that. So now you get a Christian site which wants to do Christian weddings, and all of a sudden what we do is we bring the full power of the Twitter estate against people and blow up their site. This is deeply wrong. So the libertarian instincts you have require that the freedom of choice of an individual or institution is against the background in which all such people are free from similar situations, and they don't do it. And this, by the way, is a serious problem for Harvard. Let me explain what the problem is. Harvard has a bad reputation amongst many conservatives. And so it could translate in two ways. Gee, I'd love to get into the place in order to reform these guys. Or it could be the hardest thing about Harvard is getting into the place, at least into the college, because there's a bunch of intellectual lazy bone. And I have many of my best students who come up to me and they've been to places like Patrick Henry College and so forth. I said, well, you had such terrific grades. Did you want to go to Harvard? I said, why do I want to go to Harvard and get a second-rate education? So what's happened is that not only does Harvard not want conservatives now all of a sudden don't want them on Harvard. And they're right. The Harvard degree in the college has doubtless been cheapened by all of this particular stuff. I mean, when I see my own students, I get many splendid Harvard students, but they're given a run for their money by the kids from Hillsdale College and from Grove City College and so forth, who have stronger boards, stronger grades, and better grasp of fundamentals and a non-entity reputation. So you can't play the Harvard game and not suffer reputational losses. And I think the Ivy Leagues in general are doing it. It's not going to affect their admissions abilities, because they'll still get a huge liberal constituency. But oddly enough, they will find it harder to get intellectual balance because there'll be fewer students of a conservative orientation who want to run through that particular min-will and get themselves hit in the head everywhere. I mean, internal intolerance at Harvard has been raised to a fever pitch, right? We can have wonderful debates between the left and the far left. We don't need anybody who believes in market principles. After all, we know from that great political thinker, Joe Biden, that Milton Friedman is no longer welcome here. I mean, the thought that this second, third, fourth-rate mind of no intellectual distinction will be so dismissive to one of the great minds of the 20th century shows you just how unreal the discourse is in certain high places. I mean, the president is one of the weakest intellectuals I've ever seen in my life, and he's sitting out there acting as though he's not only grandstanding for affirmative action, but he's trashing people who are so much as intellectual better that they shouldn't be mentioned in the same sense. Hell, the same paragraph, same article, same universe.
So bottom line it for me, do you think that the court made the right decision in the Harvard case, in the affirmative action case?
Look, as a matter of principle, it's again all second best. I agree with you. I would love to be able to leave them alone. But on the other hand, the process has become so convoluted. There's a clear statute that they're in violation of. They know it. Everybody else knows it. They're not in favor of the abolition of the statute. They just want an exemption to the statute for themselves. So I have a lot of sympathy for your principle and zero sympathy for Harvard University under these circumstances. And the way they behave themselves afterwards shows that they really don't kind of get the enormous claim for privilege that they're trying to make over everybody else when they support an anti-discrimination more generally and insist that they've complied when they haven't. And that's a form of hypocrisy. So that gets you back to the bad faith issue. So I'm terribly torn about all of this thing in the way in which it goes. In a first best world, they should do that. In the first best world, they shouldn't get the grants. Now, I should mention something about the grants. Because this is a huge problem. The single greatest structural weakness in the American Constitution is we're pretty good in trying to deal with how you regulate the imposition of coercion by the states. But we're very lousy in dealing with the question of how it is that the government distributes benefits to various people. Virtually everything is a protection from, right, not an authorization of. And by the time you get to the time of the Civil Rights Act, There is almost no such prohibition that deals with these things. And so when it came to Brown v. Board of Education, now you got to have a segregated benefits, and then chamber, and then you can decide to give benefits to blacks that you don't give to whites, or benefits to whites that you don't give to black, because there's nothing in the Constitution that tells you how to do that. And so at the time, everybody was in favor of 40 acres and a mule, only to black people. What about the white people? They just didn't think of it that way. It becomes, of course, absolutely crazy when you have a segregationist South to keep to that position. And so then the question is, what conditions can you start to attach to grants so as to make sure that people behave in a proper manner? So here's an easy one. I want to do a scientific grant, and it turns out you're not allowed to spend any of the money on the grant on booze and liquor to entertain people after hours. Or that you're not allowed to take a grant, which is to try to look at cell biology and treat it to do study of African custom. All of these limitations on subject matter essentially designed to advance objectives that are perfectly defensible. That is the creation of knowledge for public goods on which private enterprise can rest. So we want to develop basic principles of science in the public space, and then let people use them to patent their own inventions and so forth. So perfectly good. But now suppose it turns out we're like the Secretary of Commerce and said, well, I'm going to give out all these particular grants, but you have to supply childcare for poor people in this thing, right? And she gives an endless set of conditions that are attached to these grants, none of which are designed to advance the program of better research with respect to the climate change and its control mechanism, all of which are designed to advance the pro-union agenda that Joe Biden has put into play, which is collateral to purpose. So I've always thought, and I wrote a book called Bargaining with the State, that when you get these illicit purposes used as conditions on grants, you have to strike them down. Otherwise, what will happen? The world become generally crazy. So I could say to you, I'm going to basically give you an automobile subsidy, but not if you put a Republican bumper sticker on your car. And so you get that, or I'm going to basically allow you to use the public roads, but only if you waive all of your Fourth Amendment rights to be free of a reasonable searches and seizure. Now, we don't do any of those things. It's because we understand that privileges that are given have to be conditional. Why is that? Because the power of the state to do this today is 1,000 times stronger than it was at the time of the founding, right? We didn't have any public roads or any public grants in that form. Even then, by the time of the New Deal, public expenditures were relatively a small part. Now they've mushroomed to cover everything. And so the crisis that you get with Harvard and with everything else is, what do you do with those conditions? So to give you the famous one, the Solomon Amendment question, is we will only give you medical researchers if you will lead to allow government recruitment agents to come on campus. Remember that debate?
Yes.
Some years ago. And what happened is many law schools said, well, the Army at the time did not admit homosexual men or women into the services, so we're not going to let you come on base. And the Supreme Court basically said, tough. Under these circumstances, it's an essential function for the state. And if you don't like it for those reasons, there are lots of things you can do, including urging your students not to attend any of these sessions. But what you cannot do is to simply bar people from coming on campus because of your own political biases. So that's the underlying question that creates all the tension when you're dealing with these kinds of grand stuff. And we now know that it just cannot be the case that all grants can be conditioned in any way, or that no grants can be conditioned in any way. So what's the difference? I use the antitrust law test. Government's got a monopoly power on the grant. And the question is, they're trying to make the grant more efficient, which is fine, or they're trying to achieve some collateral objective by way of restraint of trade that they couldn't do otherwise, which means that the pro-union stuff and so forth is all bad. That's not the test that's entirely set by the Supreme Court, to put it mildly, although it's part of the intuition. But I think that explains why it is on part two of your question, you've developed something of a profound uneasiness.
You know, Professor Epstein, I really wanted to talk to you about multiple of these cases, but you've really got me going in a different direction now.
That's
because
okay.
it seems to me that the problem, like, I don't see in my reading of the Constitution, granted, I'm not a scholar, but I have read a lot of this stuff. I've read the Constitutional Convention debates, the Federalist Papers, and I remember in the Federalist Papers, the argument made, and when they were having the Federalist versus anti-Federalist debates,
Yeah.
that anything not granted is retained. That if a power is not granted to the federal government, they simply do not have it. Now,
That's
Hamilton, of
correct.
course, made that argument in the Federalist. And then afterwards, when he wanted his bank and everything else, then he switched and said, no, if it's not denied, then we have it. But it seems to me that if we I don't see where in Article 1, Section 8, all these grants and all these administrative agencies are even allowed. Of course, they would. I mean, I suppose they would wiggle it in and say, well, the necessary and proper clause.
No, you're talking about a very profound difficulty. You take something like Humphrey's Executor, right, from 1935, in which they create the FCC as an independent agency, or FTC. And then, you look along and check the constitutional articles 1, 2, and 3. And I say, hey, doesn't seem to fit in any of those. So what is it? And you know what they call it? They say it's quasi-judicial. Now, what does that mean, right? Or quasi-executive. What does that mean? It's not quasi-legislative. In fact, what it is somebody came up with the bright idea that the traditional structure was not good enough because we need independence and expertise to run these things, and it'd be too great a concentration of power in the hands of the president to say that everybody works from him, and it would be a real mistaken judgment given the judicial function and the rulemaking capacity. So I have a partial solution to that, which I think is right, which is we may be willing to consider these grants under some circumstances for some things, but that you can never, ever mesh the judicial power in with the other two. That those things have to be put elsewhere. And this has now reached a fever pitch, and is going to be up at the court next year in a case called Jarkozy. It's been received very bad treatment up to today, which is, can the SEC decide to punish somebody for a very serious offense and then appoint a given member of their own choice or their own panel to decide the case instead of the district court? And my view is you are not allowed to do that. The judicial function must go to an independent body. And for you to allow somebody to appoint the judge who's reliably on your side, or a panel of judges who are your friends, is not there. In the judicial system, we have a principle known as judicial rotation. Are you aware of that? It's not in the Constitution as such, but everybody's worried about the Chief Justice picking his favorite judges to decide on his favorite cases. So what happened is, the usual rule is you put all the names in a hat, and then you have a system where you pull them out, give people roughly equal loads, but nobody knows who's on what case. And in fact, the assignments are probably not made until very late in the day, early enough for them to review the records, but not so early. And they're not made publicly until basically the day of the case, because we don't want people writing opinions for Judge X and Y, and therefore we don't let them know that X or Y are there. It's a whole effort to do this. Well, there's a man named Cameron Elliott, I believe, and I think he's probably decided 100 of these cases, 99 of them for the government. I don't want that. Same guy being appointed over and over. He said, we have a right of appeal. Let me put the sort of lumber to you. The district court judges can ruin appeals by the way in which they shape cases. I am utterly amazed in my feeble litigation career as to how much power a district court judge has. They could allow oral argument. They could not deny it. They could allow discovery. They could deny it. They will give you extra time. They won't give you extra time. They'll write a memorandum opinion that doesn't give you a chance to talk. I've been put into so many holes in so many cases by bad district court opinion. The thought that somehow or other, oh, don't worry, it could be affected on an appeal. It's crazy. Not to say you want to get rid of the appeal, but if you think in effect that a good appellate process is going to negate a very one-sided district court process or a tri-facting process or fact-finding process, the answer is no. And so that's why I want these guys out. Now, I don't care about Article 3 courts. I don't think Supreme Court justices should have lifetime terms. No other place in the world they do. But you can create long 15, 16-year terms and then have rotation in office and achieve independence on the one hand and impartiality on the other. And so of all the reforms announced for the Supreme Court, when they had that commission, remember the Biden commission that he put together? The one that I found most attractive was, in fact, limiting Supreme Court terms. And that you must do by constitutional amendment. There's no getting around it. It was just a big mistake. So, you try to do that. And now we allow Article 1 courts everywhere else. And the reason why people like them is you could give limited terms. And so you will never see the creation of another Article 3 court. And how did we get Article 1 courts? Well, it's a very long and complicated story. But suffice it to say, as is often the case, these courts were in operation, strangely enough, for 40 years before somebody actually realized that they were subject to a possible constitutional challenge. And so by the time they were so embedded in the structure, nobody wanted to get rid of it. That is what happened in practice in the mid-19th century.
What you're describing to me reminds me of an article I read about, I don't know, 15, 20 years ago by Chris Matthew Sciabara. It was, or it might not have been by him, but it was based on his book, and it was called Toward a Dialectical Libertarianism. And they gave an example of a pharmacist and the pharmacist not wanting to prescribe an abortion pill. And they said, well, the libertarian instinct would be to let the pharmacist do what he wants. If he doesn't want to prescribe, give the pill, he doesn't have to, he's not prescribing, but he doesn't have to, sell the pill. But the problem is he's receiving government money. He's receiving government money all the way through his education. The pharmaceutical companies are receiving government money. And it just seems like it reminds me of a spider web, that all these things are just so interconnected that in order to get to the point where we could actually have a free society, you'd almost have to rip this thing apart. I mean, you've got unconstitutional courts, you've got government grants going here, and then they're conditioned on this. So the arguments end up being all within that sort of system.
Well, I mean, essentially what happens is if you take one bad step, there are two ways you can go. One is to try to step back from the status quo ante. The other is to take a second bad step to offset the first. But the second step never quite does that. So you take the third step and the fourth and the fifth. By the time you notice it, you can't go backwards and you don't know how to go forwards, which is what you're complaining about. And of course, it's very serious. We could basically penalize those pharmacists who refuse to give out abortion pills, change the administration. And now we punish anybody who does want to give out the pill, right? Yeah. And so, I mean, it's not as though the conditions that different governments can pose will be consistent with one another. It is often exactly the opposite, that they're completely inconsistent with one another. And competitive industries are nice for that reason. Now, the interesting case is, you take the cake case. If you go back and look at the 10th Circuit decision, it made the dumbest antitrust argument in the history of the world. And it said that Miss Smith was a monopolist because she had very unique talents. So that meant there are probably 10,000 monopolists in the cake industry instead of one competitive industry. It was such a stupid argument that wasn't even raised again in the Supreme Court. Where the point was that the reason you don't worry too much about the disappointed customer is there's so many other places where he can go in order to get his cake. He doesn't need to force these people down their throat. But there's another case where a woman is on the Public Records Office and she does not want to record a same-sex marriage when they're lawful in the state. Well, you can't, since she's a monopolist on that thing, you can't let her do that. So what you have to do is say, okay, somebody else in the office is going to have to do it. And then if you don't have somebody, you have to bring somebody in from a nearby county in order to do that, right? And that is the correct way. Now, somebody came up with this harebrained suggestion that if Miss Smith doesn't want to make the cake herself, her employee can do it. She doesn't have any employees. She's supposed to hire somebody just to make cakes for people that she doesn't want to do, that she's going to supervise. No, in that case, you don't have a monopoly or anything close to it. So go down the street and get it to somebody who wants to do it. And I can assure you, the question I always ask in these cases, is there any gay person in the United States who has not been able to get wedding cakes or similar services provided because people like Miss Smith and the cake master don't want to make them wedding cakes of photographers? And the answer to that question is no, there's not even one. There are 10,000 people who are eager to do this work, and you're getting upset because there aren't 10,001. Whereas this poor woman, you're telling her, you either get out of this business entirely or you take people who do things that are contrary to your industry. The choice of the equity seems to me to be just painfully easy. And I see everybody going into an absolute fit on this sort of thing. And I think the answer is, if you really don't like this woman, don't give her your custom. But remember this, not a single one of these bakers has ever said, as some people have implied, I don't want to serve a whole class of people. Now, why is that? Well, you look around the society today, you don't know who's gay, you don't know who's straight, but everybody you know who's straight knows somebody who's gay in their own family, friends, or whatever it is. So you really want to win business, you say, we'll not take gay customers. Suppose you just put that sign up, right? You're going to lose half your straight customers and all your gay customers. Okay, all right, so who's going to do that? Nobody. And so you see Miss Smith saying, You want me to make you a cake for a completely non-religious ceremony, right? Your son has graduated from high school. He's been made the Olympic team. Come right here and I will serve you along with everybody else. So the principle is self-limiting. And then what happens is you see people announcing, like Judge Sotomayor, there's now a principle that says you don't have to serve gay people if you don't want. When in fact, the principle is an excessive dealing with expressive activities that deal with profound religious beliefs. There's no compelled duty to serve by people who are willing to serve you everywhere else. And those are very different propositions. And so you get scaremongering come out of all this stuff. This is a very self-limiting prosecution. And why is that? Because in a marketplace, you don't want to exclude customers except for very good reasons. You want to include them if you can. And these people are wrestling with a serious dilemma. And what they've done is they've tried to find an honorable solution to it, and they're castigated as if they didn't try at all. It's the same thing with some of these other programs on who says conceptions and so forth. Contraception is a very controversial subject. Catholics and Protestants have different views when life begins and different views as to what procedures are and not. But when you have the Hobby Lobby case and say, oh, none of this matters, we could just force your insurance company to pay for all this stuff. It's crazy. Why is that? Because for a very nominal fee, any woman, any man can find contraceptive assistance, whether they're gay or straight, single or married, by going to a marketplace. So if they just take a little bit out of their salary, they're going to be fine in terms of what's happening. And so why the coercion when there's so much choice? And that's the question that the dissent in essentially the Cake case never were able to answer.
So I know you have to go, but I have one question for you because you
sure.
really got my mind thinking. If we're ever to establish a free society, and God knows, I know it's a long, long shot, the administrative state would have to go, correct? I mean, it just has to go.
Well, no, it has to be limited. So one of the things I like to do is to ask people to tell you, what did the administrative state look like in the 19th century? Right? Well, there were lands that had to be sold off. There were patents that had to be granted. There were military people who had to be hired. There were construction contracts that had to be let to a whole variety of services, right? And you start looking back at that particular body of law, and you don't say, oh my God, what are these people doing? And then, of course, there were other things. You need an administrative state to put together a tax roll, insurance rolls, voting rolls, right? You know, just think of all the things you have to do. Now, those things are fine. What you don't like is the modern administrative state, which can take from A and give to B in terms of who gets a permit and who does not. And so to give you the classic case of that is there are two plots of land on opposite sides of the street. Both of them are zoned essentially agricultural. And the government comes along and says to one guy, you know what? We really need to have a supermarket here. Please build one. So his plot of land goes from, say, $5,000 to $100,000 because he could build it. Guy on the other side of the street, they say, well, we already have a supermarket on the other side of the street, so you have to stay that way. And your land's still worth $5,000. You know, that permit power is huge. It leads to huge swings of wealth. It's completely crazy. It doesn't explain why you don't want to have two supermarkets side by side in competition. And so what I think you're really opposed to is what I've called for a long time, the very broad use of the permit power, which essentially has become quite crazy. I did a recent piece in the Defining Ideas column in which the geniuses in New York State decided they want to solve the problem of global warming. And how do they want to solve it? They want to tax people in residences that use dirty fuel. And they posed a law for this. Now, it turns out to comply with the law costs millions of dollars. Not to comply with the law costs you hundreds of thousands of dollars. So you're better off not complying. So the fine is just a naked fine. And then you ask yourself, do we really think the way to solve the global warming problem, which is created by Chinese coal plant, is to tell these folks that they have to reduce their pollution by 0.00001% of the world's population? Well, these folks, the interesting thing was I said, look, this is just environmentalism gone crazy, which happens a lot in the United States. But what was interesting about the local folks is they're progressives. They're not like me. They all believe global warming is a terrible problem. I think it's a thing to worry about, sort of. Every one of them is in favor of keeping the laws. But what were they in favor of? exemptions and postponements for themselves, right? Well,
Big
I mean,
surprise.
they're not even self-conscious about this. So please give us another 5 years. That make sure that if your average tenant earns less than so much money, don't do this. If the cost of repairs are this, give us a subsidy, whatever it is. What they never bothered to ask is, why do you want to do this program? Well, the same thing with the SEC. It has programs to impose, and this is why you want to get rid of the administrative. They want to basically force you to disclose all the pollutants that you create, which is not easy if you're a big company and you have 4,000 plants in 16 different countries, right? And then they want you to figure out all the pollution that is created by your suppliers, of whom you have 25,000, right, in different locations, whose businesses you don't know anything about. Got to do that. And then you have to figure out the effect of everything that you do on every downstream purchaser of any of your goods, right? Now, how much do you think you can save in terms of the carbon dioxide content of the world by these devices? But just giving disclosure. I can't even think of a number that's large enough to be remotely plausible. We have basic measures already, and we have big disputes as to how much carbon dioxide we do or do not want. And so the only debate should be, we think the total's too high, we'll ramp up a carbon dioxide tax. We think it's a problem that's not taking place, we won't do anything. We think it's a problem that's serious, but we'll find some other way to deal with it. They don't do that. So what you do is you have this obsession in the modern administrative state that no matter how inappropriate the particular entity is as the base for taxation or regulation, we're going to make them disclose things that do things. And so what's going to happen is there's now a rebellion taking place. You see it in Queens where they don't want to do this. Then they want to put, I don't know, these ridiculous solar energy platforms off the coast of New Jersey. And there's a huge uproar because they say the wind and the noise and the interference is going to destroy the tourist business. Well, I mean, you got to worry about these kinds of things. And when you have a big administrative state giving crazy permits out, it doesn't happen. And so that's why you're starting to see a groundswell in this particular area. It's back to bad faith, crazy design. And in the end, ordinary people will start with a little bit, well, tax them, regulate them. But sooner or later, they realize that them is us. And at that point, we all have to start to reconsider what we think about it. So I have to go now, but I hope this was good fun, and maybe we'll do it again some other time.
It was wonderful. Thank you so much for being here. For now, this is Rational Egoist, Michael Liebowitz signing out. Remember, like, share, comment, subscribe. Till next time.